Good evening, everybody. Thank you so much for being here. I'm Janice Kaminer-Resnick, and on behalf of Jews United for Democracy and Justice and Community Advocates, Inc., I'm happy to welcome you to tonight's program. A special welcome, as well as a thank you to tonight's guest, the extraordinary former U.S. Solicitor General, Neal Katyal, and to the always wonderful Warren Olney, tonight's moderator. Thanks to our leadership team, former Congressman Mel Levine, former LA County Supervisor Zev Yaroslavsky, David Lehrer, Caroline Kelly, and Rabbi Ken Chazen. And thanks above all to our loyal audience, and that's you, each of you. You show up every week in the thousands, which keeps us going. And a special thanks to those of you who send in donations, large and small, large or small. You enable this important series now in its fourth year of continuous weekly programming to continue. Remember, we have no control over the Eventbrite process, but you also know that if you email me or David, we respond really quickly and thoroughly. So as quickly as we can. We have no staff. We're both volunteers, and we're doing this for you. So we appreciate your patience, and are always here to help you. Next week, we're very excited to bring back the outstanding Max Boot, who just returned from Ukraine. He will bring us his firsthand impressions of the war, and we'll talk foreign and domestic politics. The title of his talk, which will be moderated also by Warren Olney, is Ukraine, Russia, the U.S., and the GOP. I love that mix of title. So it should be very wide-ranging and very interesting. The following week on June 21st, we're very pleased to feature the New York Times chief White House correspondent, Peter Baker, who's always interesting and has lots of information and great and cogent analysis, and they're sure to enlighten us on his topic, from MarALago to Washington, D.C. to Kiev, the latest news. Also going to be a very far-reaching, interesting discussion. Now for a couple more announcements, my friend and colleague, David Lehrer. David?
Thank you, Janice. Welcome, everyone. Timing is everything. Tonight, we have one of the leading lawyers in America at a time when legal activities at every level and the Trump trials are causing earthquakes across the nation. A man who's argued 50 cases before the U.S. Supreme Court has a notion about what the courts are and will be up to. I will mention 3 upcoming programs. On June 27th, we'll have a special program we just arranged on a Tuesday evening. It'll be one of our American at Crossroads driving forces, our colleague Zev Yaroslavsky. He will discuss his just published memoir, Zev's Los Angeles, with LA's Larry Mantle. It'll be at our usual time of 5 o'clock. The New York Times, in describing the book today, wrote, "California doesn't tend to define its people. The people in the aggregate define the place." Zev is a definer of LA's past 50 years as a city councilman and county supervisor. On June 28th, we'll host Ron Brownstein, best-selling author and CNN and The Atlantic magazine's polling expert. No one knows more about polls, their historic antecedents, and context than Ron. We've even had Ron offer his analysis to us from London when it was 1 o'clock in the morning there. We knew that his was the analysis we needed, and he was kind enough to oblige us. Pat Morrison will be his interlocutor. The following week, we'll have UCLA law professor and frequent guest here, Rick Hasen, one of the nation's leading experts on election law and threats to the election process. We have purposefully delayed his visit until June 28th, when the U.S. Supreme Court should have ruled on some important election-related cases that Rick will explain to us. Now I welcome a founding member of Jews United Executive Committee, a critical force network, former Congressman Mel Levine. Mel?
Thank you, David. It's such a pleasure to be able to welcome Neal Katyal to our hourly show tonight. I can, speaking for myself, and I think for many, many people, when I hear that Neal is going to be on MSNBC, which he is with a great deal of frequency, I really look forward to it. He's always right on point and as knowledgeable as can be about the issues that he discusses. On a personal note, it doesn't hurt that I regularly agree with him, but beyond that, I think lawyers especially greatly appreciate his keen legal analyses that were treated to both on TV and now through this program. Briefly, just a few highlights of Neal's incredible career. He served, as Janice said, as acting Solicitor General of the United States. He is both a professor at Georgetown Law School and also a partner in a top law firm. He spent 3 years as the special prosecutor for the state of Minnesota in the murder of George Floyd. He has been named the Litigation Lawyer of the Year by American Lawyer Magazine, and he has already at a tender age argued more Supreme Court cases than any minority attorney, breaking the record that was previously held by the extraordinary Thurgood Marshall. So we're very delighted to have him speaking with us tonight. He'll be interviewed by the much awarded Warren Olney, who spent many decades as the host and executive producer of To the Point, which originated on KCRW. He is the only two-time winner of the Los Angeles Society of Professional Journalists Distinguished Journalism Award, and he's received over 40 awards for broadcast journalism. We're very fortunate to have Warren be one of our key interlocutors. And with that, I turn it over to you, Warren.
Well, Mel, thank you so very much. And David, thanks to you as well. And Neal Katyal, it is a real privilege for me to be able to interview you. So we're delighted to have you on the program, and thanks for being here.
Ditto, and thank you for having me, and it's a privilege to be interviewed by you.
I just want to say to the audience that don't forget you can send your questions to David Lehrer. He will email them to me, and after a few minutes, I will try to give you some part of the action, as we always do on this program. So, Neal, Politico says tonight that former President Trump has been notified in a letter that he is the target of an ongoing criminal investigation by the Federal Department of Justice in the stolen documents case. We all knew that already. What's the importance of this official notification?
Neal, you're muted.
Sorry, here we go. So I was going to rephrase the question to say, why is this night unlike every other night? Why is it different than every other night? And on this night, Donald Trump has been notified, according to news reports, that he is the official target of a criminal investigation. I'm pretty sure, I'm not 100% positive, that that is the first time in United States history that a former president has received such a notification from the federal government. A target letter doesn't mean that you're definitely going to be indicted. It means you're likely to be indicted. It means that you are the actual person they're looking at. They also have the phrase in some letters that you're the subject of an investigation. Subject doesn't necessarily mean that you're criminally being looked at, but this does. So, you know, it's possible that these news reports are false. They've just been, you know, coming out over the last few minutes. Trump has already issued something of a partial denial, telling Maggie Haberman of the New York Times that it isn't true that he's received notification that he will be indicted. That to me isn't actually denial of the target letter, because the target letter doesn't generally say you're going to definitely be indicted. It just says you're the target of a criminal investigation. So I'm not sure that Trump has actually denied the story. That gives, you know, if I had to guess as to what's going on, that letter was received by Trump's attorneys beforehand. That's one reason why Trump's lawyers may have showed up at the Justice Department on Monday for that 2-hour meeting with Jack Smith, the special counsel. We don't know, but that's possible. All this is, you know, probably the most likely explanation of what's happened. But at the end of the day, we do know that this special prosecutor, and we can talk about what a special prosecutor is and so on, but this guy, Jack Smith, is using the federal government's powers to investigate two different things, the stolen documents at MarALago and the obstruction afterwards. That's one set of investigations. The other is Trump's role in January 6th. And with respect to the former, it looks like he has now concluded that Trump should be charged with the violations there. Again, anything can happen. He can be talked out of it. He could be overruled by Merrick Garland under the special counsel regulations. There's a whole bunch of stuff that could happen. You know, it doesn't necessarily mean that we will see an indictment against Donald Trump. But if I had to guess as to what's going on right now, it's number one, Jack Smith has decided that Trump is not just a target, but that will be indicted. That two, he will go to the grand jury, if not tomorrow, in a matter of days, to seek the grand jury's permission to indict Donald Trump. That three, Merrick Garland will have some review over this, the ability at least to review it. And my guess is Garland will defer to whatever Jack Smith says, unless there's something really preposterous and crazy that Jack Smith says. And so ultimately, four, it means Donald Trump will be indicted, that he will be facing a case called the United States versus Donald Trump, in which he will be accused of violating the Espionage Act and a variety of other federal statutes.
The Washington Post is reporting today that this case, which we're talking about the stolen documents, will be brought in Miami. Now, it's been said that a conviction would be more likely in Washington, D.C. And since he has admitted that he took the documents, he said he did it perfectly legally, but he certainly admitted it. It was thought that the case would be more likely to be there. So why in Miami?
Yeah, and again, this is another story that's just broke in the last couple hours. And so we'll see whether it holds up and what exactly its import is, and perhaps find out a little more about the sourcing of that story. But you're right that the story does claim that Smith is seeking to bring the bulk of the charges in Florida. As I look at it, and again, I'm only looking at it from the publicly available evidence. It may be that there's other evidence that we don't know about, but the publicly available evidence suggests to me that every one of these people could be indicted in either DC or Florida. But basically, it looks like Trump decided to declassify the documents, or to make a decision to take the documents at the very least, depending on whose story you believe, in Washington, D.C. The prosecutors say he decided to take the documents from when he was in D.C. Donald Trump, in his own town hall with CNN, a couple weeks ago, said, I decided to declassify the documents in Washington, D.C. Either way, that's enough for prosecutors to have the hook for charging in Washington, D.C. Now, you then have the issue of other people on Trump's staff, including Walt Nuda, his valet, and other people, including the dude who might have flooded the pool. We can talk about what that is in a minute. But basically, there's a bunch of potentially obstructive acts which took place in Florida. Ordinarily, the rule is under venue is that you've got to charge, and this goes all the way back to the Constitution's vicinage clause, you've got to charge in the district in which the crime has been committed. And here those specific crimes, to the extent they're crimes, would be committed in Florida. So it would mean you'd have to charge some of the underlings in Florida. However, there's also a federal charge called conspiracy, Section 371, which allows basically people who have confederated together to commit a federal crime. That itself is a separate federal crime. And it has a venue rule, which says that venue exists where any overt act to the conspiracy was undertaken to further the conspiracy. So an overt act is very easy to meet. It can be a phone call or anything like that. Much of that took place in DC, I think the prosecutors could say. And so therefore, I think, that Jack Smith has his choice of whether to be in DC, to be in Florida, or to be in both. The news report today by the Washington Post says Smith has decided the bulk to be in Florida. That might be true. There may be things that we don't know, but I certainly think it could take place in either place. I think that having sat in the chair of the Justice Department, I think the Justice Department doesn't do, Warren, what you said a moment ago, and think like, well, what's the right strategic place to bring it? Which forum is better for me? The Justice Department has a really strong allergy toward thinking that way. And certainly, like, you had President Trump when he was there saying, so-called judges in the Ninth Circuit for California or so on. But the Justice Department traditionally never wants to go down that road. Judges are judges. You bring your case in the best place, wherever it is. I don't doubt that Jack Smith will do exactly that. And so I don't think he'll be sitting there and thinking about what's the more favorable jurisdiction. I think he'll be thinking, what is the right legal jurisdiction to bring the case?
I understand you've been saying, and I've heard you say it on MSNBC, that you think there will be indictments and that there's not much, that's very likely. So he could be indicted. But what about the question whether he should be indicted? What's at stake in this situation?
Yeah, so I do think both descriptively and normatively, I think that he will be indicted, and I think he should be indicted based on what we know. And, the case has been strong against Trump on the stolen documents for many months, and every new revelation just makes it stronger to me. I mean, it was months ago that, of all people, Bill Barr, this is not someone I ordinarily agree with, Bill Barr said, this is a really strong, indeed the strongest criminal case against Donald Trump, that it's a real threat to him. And, just think about all the revelations we've had since Barr said that. We now know that Trump had more than 100 very sensitive documents at MarALago, his social club. And we already knew that Trump had them even after his attorneys swore that he didn't have them. And we already knew that these documents, or at least some of them, were very significant. Some of our nation's most sensitive secrets, nuclear, other things like that. We already knew that not just a federal judge, but the nation's second highest court, the DC Circuit, the Court of Appeals, believed that a crime was committed, and also that crime was so serious that the hallowed tradition of attorney-client privilege had to be pierced. And we already knew also that another Trump attorney, Parlatore, has quit working for him. And right on the eve of these major prosecutorial decisions that we were just talking about, we also already knew that there are 50 pages of attorney notes from another one of his attorneys, Everton Corcoran, that implicate Trump. We also know that there were a bunch of dress rehearsals that Trump undertook in case the feds came in, with a subpoena and trying to search for the documents. And by the way, we also knew last week that Trump had thought the documents were classified, that he had basically no standing order that when he took documents out of the White House that they were declassified, because he said that a document with respect to Iran was still classified, even though it was taken out of the White House. So we knew all of that. That is not, Warren, the kind of behavior that anyone has ever handled classified or sensitive national security information would ever do in a million years. Before I was in the Solicitor General's office, I was National Security Advisor at the Justice Department. I handled this stuff. Nobody does this. No Republicans do it. No Democrats do it. No independents do it. It's absolutely forbidden for the best of reasons, which is, when we talk about this kind of material, it's material that people have sometimes given their lives for, both Americans and our allies. So, it deals with sources and methods, the way in which our intelligence information is gathered, both our technical capabilities, our human intelligence capabilities and the like. And our allies, have those same risks. And under the Five Eyes program, they share that information with us. So of course, if this were any other person, this guy would have been indicted long, long ago. No question about it.
What would have to be proven? What would have to be proven to demonstrate espionage? How would he have had to handle the documents for that extraordinary charge for a former president of the United States?
Yeah, it would
What would it take?
it would require the willful retention of the information after the classifying authority or government authority has asked for it back.
That's enough. It doesn't have
Yeah.
to be handing it over to somebody or showing it to somebody else.
No, you certainly, one thing to watch for if there is an indictment against Trump is there an allegation of dissemination of the information, or is it just wrongful handling and retention? The former, the latter is certainly enough. Just formally retaining the information in a way that you're not supposed to is just the most, it's literally the statute. It's a black letter violation of the law. There's no question about it. Now, if you are disseminating it, then that gives rise to additional potential crimes and additional penalties. Basically a lot of our classification regime is prophylactic. It's kind of like drunk driving in that sense. You can say, why is drunk driving a harm? If you drive home drunk and nobody gets hurt, you didn't get in an accident. It's because of the likelihood that something bad would happen. That's why we have such a prophylactic law. And same thing with respect to a lot of the classified information statutes as well. We don't want to ever be in a position to be, in which the information might inadvertently get disseminated. Obviously, intentional dissemination to the extent, Trump, and there's no evidence that I know of this, so, I'm not saying that this has happened. I'm just saying if a former president had actually disseminated it to another foreign government, to a business partner, something like that, that gives rise to additional crimes, additional penalties. But I don't think that Jack Smith has to show any of that whatsoever. And indeed, the Justice Department traditionally prosecutes people all the time who just mishandle the information, even if they don't disseminate it to some other party.
Okay, indictments are one thing, but it takes a long time for a prosecution. And there's already been a lot of delay. The presidential campaign is already underway. What kind of problems is that likely to cause for the Justice Department as it brings this case and tries to get a jury together?
Yeah, I mean, Donald Trump has, I think, said to his aides, this is reported in the New York Times, that he was running for president in order to stave off a federal indictment. Yeah. He might think that, but I think that running for office is just about as likely to stave off an indictment as drinking bleach is going to prevent you from getting COVID. There's no relationship really between the two. The Justice Department is going to bring the indictment or not, and it doesn't matter whether you're the president or the CEO of a company or the attorney general's best friend. It doesn't matter. You're going to get.
Yeah, but I'm not asking about the trial, about the indictment. I'm asking about the trial.
Yeah,
which is liable to take a very long time.
Right.
And come in the middle of the campaign.
Yeah, so I'm working up to there. So the
Okay,
first thing,
sorry.
it's okay.
I'm
The first thing,
impatient. Okay,
the first thing that has to happen is that there be an indictment. And my view is Trump announcing his candidacy for president doesn't prevent the indictment. There is a rule that the Justice Department adheres to. I think it's wrong, but that a sitting president cannot be indicted. But Trump is not, maybe in his own mind, he's different, but for the rest, and those of us in the reality based community know that Donald Trump is not a sitting president right now. He can be indicted under that Justice Department opinion. And if he committed these crimes that we're talking about, he will be indicted. Now, then the question is, when will he be tried? Yeah. There is a lot of discretion given to trial judges over when to conduct a trial. So the other case in which Trump has already been indicted in New York by the local prosecutor there, Alvin Bragg, that's a case in which, even though the indictment was last month, the trial is not going to take place until February or March of 2024. With respect to this trial, you could imagine a similar timetable in which you've got the indictment coming down soon. Trump will then try and delay things. He will likely file some motion to change venue, to quash the indictment. That means to throw out the indictment. He'll try and take what we call interlocutory appeals, which means appeals done even before your criminal case has been fully decided, to try and delay the criminal case from going to trial. I suspect those motions will be unsuccessful, but it will add to some delay. And so I think we're looking at a trial at the federal level, around the same timetable of February or March, obviously not overlapping directly with the New York State trial, but I think done, right after that, something like that. Now, if all that timetable happens, Trump is not going to be in jail pending the criminal trial. We do have a procedure in our country for the pre-trial detention of very serious criminals, even before they've been found guilty. But for the best of reasons, the Supreme Court, our Anglo-American legal tradition, to use the words of the Supreme Court in a case called Salerno, rebels against that idea of basically locking people up before they've had their day in court. And so I don't think that there's, you see this stuff on Twitter or whatever, oh, Trump will be in jail next week or so on. None of that is right. There's no chance of that. Trump will be a free person pending his criminal trial. There may be some restrictions placed on him, both in terms of, possible travel restrictions internationally, possible other restrictions on his speech, just like what the New York judge has done, with respect to this criminal trial. There may be things like that, but by and large, he's going to be free. He can campaign, he can go on the debate stage. All of those things can happen. Now, let's say that there is a trial that takes place in the spring of 24, and two things will happen. He could be acquitted or he could be convicted. That, in terms of the way our legal system is written, it's done to give Trump as a defendant every benefit possible. So the prosecutor has to prove beyond a reasonable doubt, which is the highest standard in our law, that Trump is guilty. It's not a 51% kind of thing, but you have to be really sure, if you're a member of the jury, that Trump committed a crime in order to convict him. And all 12 jurors have to unanimously agree. If any one juror says, nope, I don't think Trump did it, he cannot be convicted. So it's a really difficult standard for prosecution, which is why you see prosecutors taking so long before they bring criminal charges and before they go to trial. But let's say Trump is found guilty. He's then going to appeal. Will he be in jail pending his appeal? My general view is probably not. We'll have to see what the evidence shows at trial and the like. But in general, if you have a very strong set of legal arguments, or if you have decent legal arguments, many times judges will say, we're not going to put you in jail until your appeal is exhausted. That's not always true. Like Elizabeth Holmes is appealing right now. She's the founder of Theranos, is appealing her criminal conviction. She's serving her jail sentence now. So it's not an inexorable command. Once a jury finds you guilty, you may have to go to jail, even if you have an appeal. But that's going to be one set of questions. When I say jail, Trump is likely never going to jail. He's probably going to some sort of home confinement situation if he's convicted, as I suspect he will be convicted. Finally, the last wrinkle in this, and sorry to have to give you such a long answer, but
it's a great answer.
It's a complicated question.
Yeah.
Let's say that Trump is convicted in the spring of 24, and he files his appeals, or even if he doesn't file his appeals, whatever, he will appeal, of course, because he appeals everything under the sun. He is then, let's say, elected in November. He takes office on January 20th, 2025. On January 20th, 2025, Donald Trump will pardon himself for this. That's a difficult constitutional question. I think the best reading is that you can't pardon yourself as the president. That the kind of leading law review article on this is written by Brian Kalt in the Yale Law Journal, and it has the great title called "Pardon Me." And "Pardon Me" makes the argument that central to our legal tradition is the idea that you can't be a judge in your own case. It goes all the way back to Dr. Bonham's case in England in 1607. And here, if you're pardoning yourself, you're essentially a judge in your own case. That, of course, won't stop Donald Trump from doing something. If you say it's unconstitutional, he's probably more likely to do it. And in any event, as a formal matter, he controls the Justice Department and the prosecution power. So he can tell the Justice Department to lay off on him and order them to do so. And they will generally have to comply. So, all of this is to say that if you care about kind of seeing this trial through, and if you care about seeing the result of that trial through, you have to worry if Trump becomes president again, because the consequences of all of this federal activity that Jack Smith is doing with respect to MarALago, and to the extent there's criminal sanctions and prosecutions based on January 6th, all of that can evaporate in a flash on January 20th, 2025.
What is the possibility of social disruption. Trump supporters have already shown that they are willing to resort to violence. Trump himself has essentially called for violence, or at least is accused of that. Is that something that the Justice Department has to take into consideration, given that there's a presidential campaign going on at the same time that the trial will be going on?
Yeah, no, I'm very worried about the possibility of that kind of disruption. Trump has shown a willingness to call out essentially the mob, not just on January 6th, but other instances. I mean, we in Washington, just sadly celebrated the 3-year anniversary of, not celebrated, but marked the 3-year anniversary of what happened at Lafayette Square, last week. And that was a horrific scene in my city. And it's one that it appeared by all means he kind of orchestrated. And I expect similar orchestrations should Donald Trump be indicted. And that's a really sad thing because, everyone I knew in the government, Republican or Democrat, it wasn't about them. It was always about kind of the overall mission, the incredible privilege you have as serving in the United States government, and the way he acted as president, it was all about him. And I really do worry about it. At the same time, I don't think that's going to stop Jack Smith for one moment from doing the right thing. And I think our system is resilient enough to handle it. And if it isn't, and if we have people ever who are pulling their punches because they're worried about Donald Trump's either attacks on social media or his attacks that may turn to physical violence, then we're no better than the English in 1776.
Let me ask you a question about your own situation. And you're regarded as one of the most successful practitioners before the Supreme Court, as indicated by Mel at the outset. In your first case, your client was Osama bin Laden's driver. How did that happen?
Yes, that was my very first Supreme Court case. And basically, I had served as National Security Advisor at the Justice Department, as I said to you, when I was quite young.
Yeah.
And I was pretty much a hawk on national security issues. And we had the embassy bombings in 1998. And I was tasked with leading a lot of the legal response to Al-Qaeda and so on. And I was incredibly aggressive. And after the attacks on 9/11, that horrific day, I was at that point teaching at Yale, and I was really beside myself because I wanted to do something to help. And so I started working with first responders along with some of my students. And honestly, Warren, I wasn't very good at it. So I was still bumbling around for something to do. And then I was watching CNN one night, and the ticker at the bottom of the screen said, "President issues military trial order for suspected terrorists at Guantanamo Bay." And I thought to myself, that's interesting, because with the embassy bombings, we looked at that, the military trials, and we said they were obviously unconstitutional. So I wonder how he's doing it. So I got on my, at that point, dial-up modem, typed in whitehouse.gov, and I read the president's executive order. And I honestly thought it was a joke. I thought I was like on the wrong website. I thought I was on like The Onion or something like that, because it was preposterous that the president could be setting up an entire trial system from scratch and handpicking the prosecutors, handpicking the defense attorneys, handpicking the judges, handpicking the appeals judges, writing all of the rules for the criminal trial, defining the punishments, which he said include the death penalty. And the very last lines of the executive order said, "Federal courts have no business reviewing what I'm doing at Guantanamo Bay." That literally people could be put to death, no court review at all. And like I said, I'm a hawk on those issues, but I thought that was such a violation of our Constitution. So I came into my constitutional law class the next day, and I said, "You guys are always teasing me, thinking I'm so deferential to presidential power. Here's something that's obviously unconstitutional that the president's doing." And in the class was a very high up former staffer for Senator Patrick Leahy, who was head of the Senate Judiciary Committee, and she told him about what I said, and I got invited to testify in the Senate 2 weeks later, and I basically said that this is unconstitutional. And then I wrote a law review article about it with the esteemed Larry Tribe, who I think has spoken to your audience before. And I think nobody read that article. Maybe my mom did, but nobody else. But then these tribunals started to happen at Guantanamo, and I wanted to do something about it. And so I wrote some more articles. Nobody read those either. And then I had this crisis of conscience, and I said to myself, look, if you really believe this, you have a law degree, you got to use it. And so I created this test case and then brought it all the way to the Supreme Court. You're right, it was my first argument. It was President Bush's Solicitor General's 35th argument, but I worked my tail off. And even though that court had 7 justices appointed by Republican presidents and 2 by Democrats, we won the case. And I had a lot of incredible help from my law students around the country, as well as from a law firm in Seattle, Perkins Coie. And so that launched me into this whole other endeavor.
You just commented on the nature of the justices, who appointed them, and how they might feel. You come off as a very progressive person. You're on MSNBC all the time. That's the most left-leaning of the cable channels, I guess, at a time when the court itself is about as right-leaning as it's ever been. You have to be kind of careful about what you say.
Well, I try and be careful no matter what, whether I'm on TV or in court or
Sure.
whatever. I mean, I do obviously take a very strong view about some of President Trump's actions. I think he has put himself over the country. I think he did so from day one. On day 5, he issued that Muslim ban, which was horrific. And I had the privilege of challenging it on behalf of the state of Hawaii and bringing it to the US Supreme Court. But I think this is not a time to mince words. I believe in giving people all the benefits of the doubt. And so, and that's true with respect to these criminal allegations against Donald Trump. I'm just speaking about what we are hearing about and reading about in the newspapers that may not all be accurate. And, he will have a criminal process with every benefit of every doubt that the law knows how to given to him. And he's entitled to that. He should have that. But when we assess his policies and his treatment of the Constitution, I find them pretty horrific, and I'm not going to be shy about saying so. With respect to, the U.S. Supreme Court at this moment, obviously they've issued some rulings with which I profoundly disagree. Of course, the Dobbs decision is at the top of that list, setting us back in ways that are untold. I can't really fathom the degree of harm that decision has done. And just even not both for women on the ground, for people, men and women, but also to the fabric of the law and to the whole concept of respect for precedent and stare decisis. I think it is an incredibly dangerous decision. Having said that, I am a Supreme Court litigator, and I'm going to go in and make the case as best I can for my clients. And I just argued a case in the Supreme Court called Cruz versus Arizona, which challenged the way that Arizona administers the death penalty. And could I have gone in and said, well, the Supreme Court's, so conservative, they're not going to listen? Well, if I go in with that attitude, I'm not going to win any votes. I went in with the attitude of that justices are listening, and I made the best argument I could. And lo and behold, we won it 5-4 in the Supreme Court, with Chief Justice Roberts and Justice Kavanaugh siding with Justices Kagan, Sotomayor, and Jackson to not just save this one person's life, but potentially 30 more lives of people on death row in Arizona. So, that's my job. And, I'm very proud to do it and be part of the system. but I would be, not, it'd be wrong to say it's not that it's an easy job. It's a harder job
Sure.
now than it's ever been.
Well, it's extraordinary to hear what you have said, but I did promise that I would give the listeners, or the viewers, I should say, an opportunity to ask questions. And the very first one is this: Carol wants to know what can be done about Justice Clarence Thomas and apparent ethics violations.
Yeah, that's well beyond my purview. There's obviously some activity going on the Hill and the like, but that's not something that I can address.
Okay. Ellen asks, what's your surmise as to why Trump kept the top secret documents at MarALago?
Yeah, that's a great question. And again, it's all speculation at this point. We don't know anything authoritative. I can tell you that when I was a national security advisor, I definitely saw people who retained documents, not because they wanted to disseminate it, but because it gave them some sort of special thrill to have these documents. And it's certainly possible that that's all it is that. Or maybe it's, Trump does sometimes act like a 3-year-old and it's mine. So it might have just been, some kind of weird 3-year-old view of property rights. I don't know. Or it could be, as some people have said, everything Trump does is transactional. Why would this be any different? Why wouldn't he take this to monetize it in some way? That's obviously a very serious allegation. I'm just listing out the various possibilities as to what it could be. No doubt that is something that Jack Smith is trying to figure out. What was the criminal motivation for stealing so many documents, for keeping them stolen, for lying about it afterwards? It could be any of these three, or maybe some other possibilities. That's, I do think something that we'll start to see unfold in the criminal process.
David wants to know, what are your thoughts about the Georgia election interference case, the call to the Secretary of State of Georgia, asking
Yeah,
for
it
votes?
certainly looks, if I were representing Donald Trump, I'd be quite worried, because you've basically got Trump caught on tape. He's obviously upset about the fact that the Secretary of State Raffensperger was taping him, but he was, and you have on that tape, saying, "Go find me 11,780 votes," which is certainly not the way a candidate should ever talk to an election official, whether, and even more so if you happen to also be the president of the United States. So it's obviously deeply morally problematic. For me, it would be disqualifying if someone from my party, the Democratic Party, did that. I could never vote for that person. The question is that criminal? It looks like under Georgia law that it is. And it looks like that, again, we're just reading tea leaves, but it looks like the district attorney, Fannie Willis, in the case has concluded that it is as well. She had said a couple months ago that indictments would be imminent, and there were some grand juror appearances, which also I think people led to suggest that the grand jury had voted an indictment of Donald Trump. And then all of a sudden everything stopped. And we know that the Willis has said, well, decisions now in August or September. The thing that likely has happened is that some of the defendants in the investigation, there's the 11,780 piece of it, but there's also this fake electors scheme, this idea that some of Trump's lawyers and others had to basically throw out the popular vote in certain states, including Georgia, and replace them with delegates picked by the Georgia General Assembly, the Georgia legislature, or the Arizona legislature, and in that scheme. Now, some of those folks had been given plea deals. They're all represented by the same Trump paid lawyer, evidently, according to news reports. And the plea deals weren't necessarily communicated to those folks. So that's an obvious problem. If it happened again, we don't know, but that's what I think Willis is looking into. So that's created a snafu with respect to resolution of those cases. But my strong gut, based on the tea leaves, is she's concluded that Trump's guilty, that the 10 or so fake electors would only be gravy and enhance those prosecutions, if anything. But I don't think that that's going to be a stumbling block to her indicting Donald Trump, should it happen, should she make that decision.
Don wants to know, is there any merit to the argument that Trump could unilaterally declassify top secret documents? I would add, just by thinking about it. It's something that he has said at one point.
Well, it would require him to think. So that's number one, might be a problem. But this idea that thinking about declassification alone is enough, I'm not sure that that would fly, because there's a pretty robust set of procedures for declassifying for the most important of reasons, which is you want to get input from the intelligence community and the like before you do that. There could be any number, like sometimes you'll see a document that's classified. And you're like, why is this classified? I think I read something really similar in the New York Times, but there's maybe something in there that reveals the possibility of a source or a method, either a human person that we might have on the inside or some sort of electronic capability. So that's not always immediately apparent when you're reading the document. So that's why you have a declassification process. Now, certainly the president can skip, under our Constitution, the declassification process. He absolutely can. But you got to have some proof that that's what you were doing. It can't possibly be that you just did it. I mean, there's a reason the law insists on formalities in various ways. It's just like if Donald Trump, comes back tomorrow, let's say Jack Smith does. We haven't even talked about this yet. But there's a whole other part to Jack Smith's investigation, not the stolen documents at MarALago, but Trump's role on January 6th. Okay. Now, let's say that Smith decides to indict Trump for that. And Trump says, oh no, I pardoned myself on January 7th in my mind. That can't possibly be right. You got to have some formal proof that you did it. Now, he may have done that. He might have put it on a napkin, put it in a suit coat pocket, and so on. And then we'll have that whole debate, can a president pardon himself, and so on. But before you get to that debate, the law insists on those formalities for the best of reasons. It's why, you sign documents when you're, getting married, or when you buy a house or whatever. You can't just sign it in your mind. You got to actually do it. And so, I don't buy this idea for 1 second that he declassified things in his mind. The stronger version he's made of the argument is that he had a standing policy that if you take documents out of the White House, then they were declassified automatically. Now, the only person evidently who believes this is a guy named Kash Patel, who, his credibility is, I don't have an adjective for it, but you can imagine
We can infer what it is.
Yeah, it's not great. So, if I'm a criminal defendant, he's pretty much the last guy I want as the one person backing my story. But in any event, so even if that's true, that he believes it, there has to be, some reflection in the records or something. You can't just say that you had a standing order to do it. And it would make no sense, because once, documents were removed from the White House, in various ways. And if they were automatically declassified, all those sources and methods would be immediately subject to, being uncovered either through a Freedom of Information Act lawsuit or something else. It can't possibly, it's just, it'd be a crazy way to run the government. If it is the way he ran the government, again, it's disqualifying as someone to be commander in chief. And then you've got the further problem that story has been blown apart by Trump's own actions in two different ways. One, I think it was the day before he left the presidency, January 19th, he declassified a lot of stuff about Eric Holder and others in Operation Crossfire. And he issued a long memo that said, I followed all of these procedures in order to declassify these documents. So he knew exactly the way in which the declassification system works, and he signs that. The second is this tape that came out last week, in which Trump is caught saying on tape, This whole story General Milley's telling about Iran is wrong, and I have the documents to prove it. Oh, I can't give you those documents, and he's evidently rustling them on the audio tape. You can hear him rustling it. I can't give you those because they're classified. Now, if he had a standing order that anything taken out of the White House would be classified, then those very documents would have been declassified. So the best way I think to think about this is Donald Trump is acting as if he's too dumb to even play dumb. I mean, if his defense is that he declassified these documents by taking them out of the White House, then he can't be going around saying these are classified documents. So it's not a consistent story.
Paula wants to know, what are your thoughts on the possible expansion of the Supreme Court all the way back to FDR?
Yeah, the expansion of the Supreme Court's been threatened, as you say, since FDR. The Constitution doesn't fix a number of justices. We have had 9 since 1867, but we started with 5. We then went up to 6. For a while, we had 10. And, I've argued before even numbered court, the U.S. Supreme Court, after Justice Scalia passed away, there were 8. And every so often, I have a justice recused for one reason or another. And so there are only 8. And it's a really weird thing with 8, I have to say, because if there's a tie vote, then no precedent is set by that decision. And so it's really, I think, important to have an odd number. That's the first thing I'd say. The second is, I think, as a practical matter, it's impossible to think the Supreme Court is going to expand, because you would need a law of Congress, and that law of Congress would have to be passed by a majority in the House and presumably a supermajority of 60 in the Senate, unless they wanted to try and go nuclear on the filibuster and make it 51. Even if all of that happened, and it wouldn't happen, of course, right now, given the composition of the House being Republican, but let's say something changed and the House and the Senate both flipped to Democrat, and they both were able to the Senate was able to overcome the filibuster threshold. Is it a good idea? You'd have to worry. Let's say the Democrats bring it to 15 seats. Then let's say the Republicans win in 24 or 28 or 32, and they bring it to 21 or 27 seats. And then the Democrats win in 36, and they bring it to 47. And pretty soon you have the Supreme Court of Switzerland or the Supreme Court of India, each of which has like 100 members, and you lose what's special about the United States Supreme Court. So I'm not wild about the idea. I do think it's really important for those of you who are as upset about some of the decisions that the Supreme Court has rendered, like Dobbs on abortion, like New York Rifle versus Bruin on gun control, like West Virginia versus EPA on climate. I think it's important to get those views out there. But I don't think it's the most productive way to talk about expansion of the court as the mechanism to deal with it.
You want to get those views out there. Is the court listening? Does it hear the views of the public?
Well, there's really good social science literature that says that, yes, that the courts ultimately always do. The U.S. Supreme Court always does come around to public opinion. It may lead sometimes public opinion, as it did most powerfully in Brown versus Board of Education, or in Obergefell versus Hodges, the marriage equality case from 2015. And it may sometimes lag in public opinion, but it ultimately does get there. And I'm a big believer that respectful disagreement is an important piece. It's what our democracy is based on. And just because we're talking about the courts and not politicians, that doesn't mean that we sit on the sidelines. It means that we make our views known, and ultimately one day those views become the law of the land. And sometimes it takes a long time. Plessy versus Ferguson said separate but is equal in 1896. It took until 1954 to get there. But sometimes, particularly in this kind of new social media, hyper-connected internet age, things can move more quickly. I mean, marriage equality, when my sister started talking to me about working on marriage equality back in 2005, I thought that was preposterous. And yet 10 years later, you have the Supreme Court doing exactly that. So, I don't mean to minimize where we are with respect to some of these decisions and decisions to come, whether it's the affirmative action decision or the decision to second guess big parts of the administrative state and the like. There's other very serious danger points on the horizon, but all of that is a reason for fora like this to, basically talk about these issues, to think about our response, to do so in a way that's measured and appropriate. And ultimately the law bends, just as, Dr. King says, the arc of justice bends, but it only bends if we work to bend it.
Sue wants to know, what about term limits for the U.S. Supreme Court?
Yeah, that's term limits is something since 2003. I think I've been on record saying that I think are appropriate for the U.S. Supreme Court. When the Constitution was written in 1787, life expectancy was not where it is now. We didn't have the same kind of politicized judicial appointments in quite the way we have now, with justices kind of hanging on so that a member of their own party, or the party who appointed them will, appoint their successor and the like. It's become a very different process. And I think the best way to deal with it is to take the average length of a Supreme Court justice's term over American history, which is 18 years, and to say every president in their 4-year term will get 2 nominations to the Supreme Court, and each person will serve for 18 years. That avoids also some of the kind of, I find, distasteful kind of almost actuarial analysis of the justices. I mean, these are human beings, and to have all of this discussion in the public about their health and stuff, I find distasteful. If it were just straight 18-year terms, I think a lot of that would be eliminated. And it avoids the kind of lottery system in which, Trump serves for 4 years and gets 3 justices, and Barack Obama serves for 8 years and gets 2 justices. I mean, that's nothing about them. It's about literally just the, circumstances of the human condition and why some get more appointments and others get fewer. Doesn't strike me as, if you were a Martian landing on Earth and you looked at that and said, wait, that's the way you do Supreme Court justices, I don't think there's a way to defend it. I think it's impossible to defend. And so I would much move to an 18-year term. That would require, in my view, a constitutional amendment. I don't think it can be done by statute. There are those who disagree and think it could. In either case, it couldn't affect the tenure, I think, at least of the current 9 justices on the Supreme Court. It would only be in a going forward basis.
You are such a master of all that you survey. It is really an education to listen to you, and I think we've all appreciated it a lot. How do you feel about the future? Are you optimistic or are you pessimistic?
I am somewhat optimistic about the future. Obviously, there's a lot of challenges that we're facing, our economy, the gap between people with a lot and people with a little, the very conservative nature over some of our courts right now. Those things really do concern me, but I also see real bright spots on the horizon. And, for me, I'm a big believer in karma. And I do think that Donald Trump got really lucky over a lot of stuff. And he also made himself lucky. He threatened, and scared off people from holding him to account. But, I do think karma's catching up at this point with him. And I never wish ill on anyone or the criminal process on anyone who's not deserving. And even if they are deserving, it's still a horrific thing to go through. And so, as a human being, I feel for that whenever it's anyone, even a president who I think really gravely threatened our Constitution. But I think that is the necessity of our system. And I'm if the news reports tonight are right, I'm optimistic that Donald Trump will be held to account.
Well, thank you so much, Neal Katyal. It is, again, a real privilege to talk with you, and I've enjoyed it a lot. It's been fun. So thank you so much.
It's been really fun for me. I really love talking to all of you. This is, I think, my second time before you, and I can't thank you enough for all the great questions and for listening. And I think we have more than 4,500 people listening tonight, and that just really, really, I really appreciate it. Those of you, I'm going to launch a podcast in 2 weeks called Courtside, which is about basically bringing the Supreme Court to non-lawyers. And we're going to do a different Supreme Court case every week and with a non-lawyer. So I'm going to have like Jeff Koons talking about copyright, and I'm going to have John Mulaney, the comedian, talking about prosecuting a president, and Amy Schumer talking about the recent obscenity case with cheerleaders, and all sorts of stuff. So I hope you all listen to that, and I can't wait to see you again.
Nobody better suited than you to do that. What's the name of it again?
It's called Courtside.
Courtside. Okay.
And I'm looking for a great basketball player to come on. So that's but that I haven't mastered yet.
Neal Katyal, so much. Yeah, so
Thank you.
so good to have you. Thanks a lot.
Thank you. Bye-bye.
I want to talk about next week. It's going to be the Washington Post columnist and noted military historian Max Boot. I'm going to be talking with him about issues both foreign and domestic, a lot of political stuff, of course. And he will update his recent visit to Ukraine and what he learned first half about the war and how it's going on. That's next Wednesday, June 14th, 5 p.m. Pacific Standard Time. Till then, stay safe, stay healthy, and have a good night.